You're listening to the Neurocareers Doing the Impossible podcast with Dr. K. Episode number 14. Dear Neurocareers podcast listeners, get ready for a new adventure on our international podcast about the careers in neuroscience and neurotechnologies. We already had a chance to discover that people get into the field of neuroscience from a variety of different disciplines, including biology, engineering, medicine, and even magic performance. Today, we meet Allan McCay, who connected neuroscience and neurotechnology with the field of law. Allan's main focus is neurotechnology, criminal law, and human rights. Welcome, Allan. Thank you so much for being a guest on our show. Can you please tell us where you're joining us from and introduce yourself? Thank you.
Sure, yeah, thanks for the invitation. I'm in my office at Sydney University in Australia, and I'm an academic fellow at the Sydney Law School, and I'm also Deputy Director of the Institute of Criminology. And I've got an interest, as you know, in neurotechnology. The Law Society of England and Wales has recently released a report that I wrote on the subject.
Thank you for your introduction. Can you tell our listeners how did you come to this field of neuroscience, neurotechnology? What inspired you to start working in this field?
So that's actually, it's quite a long story, really. When I was an undergraduate, through doing criminology, actually, I became interested in the free will debate, the question of whether humans have free will and whether they're responsible for their crimes. That's a particular interest. And, in the context of criminal law, I sort of left it for a while, and then I went and became a commercial litigator for a while, and then came back to teaching law. And I decided to do a PhD, and I decided to do a PhD that would enable me to discuss some things related to my interest in free will. So I did a PhD on behavioral genetics and sentencing. And I imagined that somebody using evidence from behavioral genetics in a plea and mitigation to try and get a less severe punishment, as some people have, particularly in America and also in Italy, actually. There's not a great number of cases in that area, but I got involved in a project called the Australian Neurolaw Database, which is a project that's a joint venture between the University of Sydney and Macquarie University, which is another university also in Sydney. And we started looking at cases where there's some discussion of evidence from neuroscience. Most of the ones I looked at were in the criminal law, but the project is a bit wider than that. The Australian Neurolaw Database, you can be found on the web and it's open access. You can sign up for it for free to look at the cases we found or the summaries. We looked at cases where there was probably some expert evidence from, say, a forensic psychiatrist, and maybe that forensic psychiatrist might refer to brain scan and a question about what should the court do. Let's say there's somebody's brain scan, it looks like there's, some issue with the frontal lobe and there's expert evidence to that effect. There's a question about whether that should lead to a lighter sentence or not. So that was a sort of legal dimension to this. But then sort of separately, I got interested a bit in AI, artificial intelligence, and there was a judge in Sydney who had the unusual distinction of being quite an accomplished philosopher at the same time as he, moved up in the courts, a man called David Hodgson. And I knew him, and he spoke about free will. And when I heard some discussions of the differences between human decision-making and machine decision-making, I was reminded of his views, and I got quite interested in the work of Yuval Noah Harari, who wrote a book about the future work. So anyhow, I wrote a piece on how human decision-making might be different from machine decision-making, and that was informed by the ideas of this judge who's now sadly passed away, David Hodgson. So I got a bit of an interest in AI. And then, of course, neurotechnologies were developing during this time. And then I started to get interested in brain-computer interfaces. And then maybe it was about 4 or 5 years ago, well, I went to this conference at the Australian National University called Brains at the Dome, and the heads of various brain initiatives around the world came and talked at this event. It was sort of a major event, and I met Professor Raphael Just, who's a professor of neuroscience at Columbia University. At that time, I was thinking about writing a paper on brain-computer interfaces and somebody committing a crime that way. You know, I'd read something about these brain-computer interfaces, but I thought, am I starting this too early? Is this still science fiction? He said, no, you should write something. So I did. And I wrote a paper which envisaged somebody committing the revenge porn offense. It's more formally called intimate image abuse by way of brain-computer interface, which I published in a book. Because I'd had this discussion with Raphael, who at that time I'd only met once. I met him many times online since. He invited me to this group where we were starting to have some discussions about neurotechnology and human rights. And whereas I'd been initially interested in neurotechnology in the criminal law, I started to realize there were many dimensions to neurotechnology, including some potential human rights concerns. Then I started to do some talks on that and publish a few things. Then that led me to get invited by the Law Society of England and Wales to write a report, which is really the first attempt from somebody in a law body to try and do a kind of overview of what neurotechnologies might mean for the law. And a big part of the aim of it is to stimulate a discussion amongst lawyers about what it means for them. What does it mean for the profession? What kind of regulation might be needed, and what should be done about it. And so that's where we are now. So that was quite a long story. That was the sort of series of steps that led me to get into neurotechnology.
I think that's a very interesting path. And I would ask you about each of those steps. Of course, the question of free will and how human decisions can be different from AI decisions. And then, of course, that third question about neurotech and human rights. Can you give a brief summary of the first two steps? And then I will ask more questions about the third. So the first was the one, do people have free will or not? What was your take on that question?
You know, I was particularly interested from the perspective of criminal law. And criminal law has got a variety of aims. And so one of the aims relates to community protection, and that might involve deterring potential offenders, rehabilitating offenders, incapacitating those that are very dangerous. So these are kind of forward-looking, and they look to the future and try to obtain some future benefits for law for the community. But there's another aim, the retributive aim, which is a feature of the criminal justice system here, and really all criminal justice systems that I know of. And that's an aim to give the offender what they deserve for the wrongfulness of the thing that they did. And the idea is that you shouldn't get more than you deserve. And you can think of an early sort of articulation of this might be in the biblical notion of an eye for an eye. So the idea is there should be some sort of proportionality between what you did and what happens to you. And then there's secular philosophers that have tried to argue for some other version of a retributive view. But the thing is, I think that in order to deserve punishment, it's important that people have free will. So if people didn't have free will, then the idea that they deserve punishment seems rather strange. It might still be the case that it's useful to rehabilitate them or deter them or maybe even incapacitate them. But the idea that they deserve punishment would seem rather strange. And that was the thing that in particular motivated me, because here's a sort of modern version of the problem. There's been debates about free will in a theological context for a long time. And if God knows everything that someone will do, how can people be free? And that's a debate that people in the theologians have considered. Well, one of the scientific versions of the problems is once you start to accept that humans are part of the natural world, then presumably we're also subject to the laws of nature. And the concern is that given the way things were when we were born, and given the way that the laws of nature apply to us, it seems to leave no room for free will, because we do as the laws of nature sort of make us, if you like. So that's one kind of a sort of simple way of thinking about the problem. Now, some philosophers have said, oh no, well, actually free will is compatible with the laws of nature. So even if determinism is true, even if everything that a person does is determined, that of itself doesn't undermine free will. And so, I and David Hodgson, who I mentioned earlier, and a variety of others, think that the free will problem is important for the retributive justification of law and perhaps for other things in law. And so that's why I think particularly criminal lawyers should be interested in free will, or at least one of the reasons why I am free will. And then I guess I also wonder if I have free will. So there's something personal about it as well.
Can you maybe provide an example from criminal justice where this question of free will was particularly important, maybe in your practice?
So I'll use the example of an influential case, which is from the Australian High Court. The High Court is the equivalent of the American Supreme Court. There is the top court in Australia. But there was an Indigenous man who'd been convicted of a very serious assault. In fact, he was from a sort of background of violence and alcohol abuse and that kind of thing. His name was William Bugney, and he'd had a very difficult upbringing. And the court had to decide whether that difficult upbringing is a reason to reduce the punishment. You might think that this upbringing might have compromised his free will, although the courts don't articulate in this way. They use other language and make him less deserving of punishment than somebody that had a less troubled upbringing. And so perhaps his free will might in some sense be compromised. The High Court did say, judges have to take account of these difficult formative circumstances, even if the offender is a bit older, because these things have implications for life. They're not just implications in the short term. So that's a legal principle that's part of Australian law, that judges have to take note of a very difficult formative environment. Sort of tie it to my own research, and to sort of tie it to behavioral genetics. There's some research from Avshalom Caspi. None of this was referred to in the case, but there is this principle that a difficult formative environment is something judges have to consider when they determine punishment. But in my thesis, using an earlier sort of similar case, the bugme hadn't been decided when I was doing my PhD, but using an earlier case called Fernando, which is it raised some similar issues. I said, well, it might be possible for a lawyer in a sentencing matter where there's a male offender who's been subject to a very difficult upbringing, perhaps some sort of a maltreatment. They might be able to say, well, here's the legal principle from Fernando, bugme, that says you as a judge have to take note of the maltreatment and maybe think at least about reducing punishment. What's more, according to some research from Allan McCay, some people, some males, so males with low activity MAOA genes in particular, are particularly susceptible to the sort of crimogenic effects. They're particularly vulnerable because of their genetic makeup to the effects of maltreatment. And so given that, my client has got the low activity MAOA gene and also he's been maltreated. And so given the bugme case, you've already got to take into account his maltreatment. But I think you should also take into account his special vulnerability to the effects of it and give him more mitigation. So that was kind of an argument that I considered in my PhD and also in subsequent writing in a book that I, Routledge Handbook of Philosophy and Science of Punishment. I've got a chapter where I consider that kind of argument.
Thank you very much for this interesting example. Adding genetics and your research to it makes even more support in this type of cases.
And actually also a reason to think, well, actually maybe more mitigation is due, not just supporting the claim that mitigation is due, say that this person is likely to be particularly badly affected by the formative environment that they experienced. I should say that, there's been some meta-studies and, like the research, the link between low activity MAOA, maltreatment, and impulsivity and aggression. But some meta-studies have supported it, and I think it's an argument that somebody could put to a court in Australia, and perhaps it might be successful, but it hasn't been tested here.
Now, the second question, which is also interesting, your second step that you mentioned, how human decision can be different from AI decisions. Can you tell us a little bit about that and maybe also provide some example where we can see it in the future as AI develops?
I don't know if you've seen the book. There's a book, Israeli historian and futurist, Professor Yuval Noah Harari, called Homo Deus, Brief History of Tomorrow. That's been a bestseller and it's been endorsed by Zuckerberg and Gates. And, I think his earlier book, Sapiens, Obama endorsed it. So anyhow, I read this book and I read his other book, Sapiens, and there was a third book, the name just eludes me at the moment, but primarily Homo Deus, A Brief History of Tomorrow. I should say I thought it was a great book. I loved it. I thought it was a wonderful book, very thought-provoking. But essentially, he regarded human decision-making as algorithmic in nature, and so not in principle different from the kind of way that automated decision-making takes place in AI, artificial intelligence systems. And so from that, one of the things he did in this interesting book, is not the only one, but one of the things he did is he talked about the possible implications for work. And in a lot of areas of work, this question about what can humans do in the workplace and what might be replaced by machines. And that's certainly a very live debate in legal practice, and certainly some legal work and some of the legal work that I used to do when I was a junior lawyer is now able to be taken over by machines. But the question is, how far is it going to go? Whereas, and Yuval Noah Harari, he thought that these non-conscious algorithmic machines decide in an algorithmic way, which is similar to the way we do. And a consequence of that is that in principle, they could just keep going and really just replace us in the workplace and lead to what he called a useless class of people that just have got no work to do. And of course, that's a major social problem if he was right. So anyhow, as I was reading this book and enjoying it and finding it stimulating, all that kind of thing, I'm very familiar with, as I mentioned, with the work of this Australian judge and philosopher called David Hodgson. David Hodgson, he's passed away, sadly. As I say, I knew him, and he passed away quite a while ago now, maybe almost a decade ago, I think. But as I was reading Harari's book, I kept on thinking, I know what David Hodgson would say, because I'm so familiar with his book, because I co-edited with my colleague here at Sydney Law School, Michael Seville. We co-edited a collection of responses to David's last book. Our book's called Free Will and the Law, New Perspectives. And I kept thinking, I know what David would say. And of course, he's not there to say it. But I thought, right, I'll write a reply. So I wrote a reply, and I published it in a journal called the Journal of Evolution and Technology. It's actually changed its name now. And if David Hodgson was right, then there's some kind of advantage that consciousness brings to decision-making that non-conscious algorithmic machines wouldn't have. And so he would push back on Harari's view that human decision-making is algorithmic, and say, no, it's not. And so if Hodgson's right, then maybe the implications for the future work are less dire. We might still be in a bit of trouble because machines can do a lot, but if David Hodgson was right, then the implications for the future work were less dire than Harari predicted. So the piece is called The Value of Consciousness and Free Will in a Technological Dystopia. That was my piece. I did actually send it to Yuval Noah Harari, and I was very pleased that he read it and gave me a thoughtful reply. So I was very grateful to him for doing that. I'm sure he's a busy man.
That's a very interesting discussion, and I think it's going on for many years already, and the people are trying to address it in sci-fi books,
Sure.
And we still cannot find an answer to that. So it's still contradictory. And no less contradictory is this field of neuroscience and neurotechnologies, and how to address the problems that are arising as those fields are developing. What are the main challenges that you identified in this fast developing field of neuroscience and neurotechnologies from the standpoint of law or criminal justice?
I think there's a lot to think about. So I think one thing to start off with is remembering the upside in neurotechnology. Helping someone with locked-in syndrome to communicate, to get some autonomy back, maybe be able to control devices, control things in their home by way of brain-computer interface. That's marvelous, miraculous, and I wouldn't want to stop that. And then let's say there's, neurotechnology to address Parkinson's or drug-resistant epilepsy now. And now there's also further research to try and address a variety of other conditions, including dementias and psychiatric issues, anxiety, depression. So one thing I think that is important for law law sets a regulatory environment. Let's hope it doesn't stop that. That's one thing. But then a variety of things to think about. I initially got interested, when I started thinking about brain-computer interfaces, I started to think about it as a criminal lawyer. The criminal law has got this long-running distinction in relation to what's known as the elements of crime. So the prosecution have generally got to prove, at least in serious offences, have got to prove two things. They've got to prove the actus reus, which is usually an act. It could be an omission, sometimes a status, but it's usually an act, like so punching someone or something like that. And they also have to prove the mens rea, the guilty mind. So something that they might have to prove that someone intended to kill, for example. So there's a mental and a sort of act dimension to it. And the act, thus far, has always been bodily. So a person uses their muscle system to pull a trigger or utter false words or to fire a gun. There's no cases that I know of where somebody has been convicted of an offence that's performed by way of brain-computer interface without use of a muscle system. But it may have happened. People have them. I'd be surprised if nobody's committed an offence yet. There's some therapeutic devices, there's some consumer devices. Somebody may well have committed an offence already, but there's no case. But there's something odd there because let's say the prosecution has to prove the mens rea, the guilty mind, and the actus reus, the criminal act. They sort of seem to start to blur because they seem to be all mental. There's a kind of distinction that the criminal law has had that comes under pressure. I published a paper called Neurobionic Revenge Porn, Brain-Computer Interfaces and Intimate Image Abuse, and it was in my book, co-edited book, Neurointerventions and the Law Regulating Human Mental Capacity, and I explored that. But then, the other thing is the issue of regulation of neurotechnology. There's the FDA in America, and here we've got this thing called the TGA, the Therapeutic Goods Administration, that regulates medical devices. But they're interested in regulating things that are used for therapy. It might be possible that neurotechnologies enhance, and maybe one day they might be able to improve someone's cognitive capacity beyond the normal range. So it's no longer therapeutic, it's kind of an enhancement. And so there's a question of, well, who regulates that? The TGA are focused on therapy. So there's a question about who regulates it. And then employment law, there's already some companies, I understand, that are using non-invasive neurotech to monitor for attention, maybe somebody driving a heavy goods vehicle or something like that. So is it okay for an employer to engage in brain monitoring? And then, in the context of sentencing, so sentencing, something I've looked at a lot in criminal law. Let's say somebody's got an issue of impulsivity and aggression and they've offended and maybe on the edge of going to jail. They might go to jail or they might not. They're just kind of on the edge of it. And let's say there's some sort of neuromodulation device that's available that can address impulsivity and aggression, maybe by monitoring the brain, using a machine learning approach, detecting the neural precursors to an angry outburst in the way that currently some devices operate to detect the neural precursors to an epileptic fit. So there's, in principle, it sort of seems a bit similar. And let's say I'm acting for that offender and I say, well, John here, my client, he's got this anger management problem and he's punched the victim, but now he's had this maybe a lightly invasive bit of neurotech that will just monitor him and intervene when necessary. And so don't worry too much about reoffending because the neurotech has kind of rehabilitated him. Instead of sending him to jail, just make an order saying that he's got to stay under the direction of his forensic psychiatrist and he's got to keep this device active for the duration of, say, the 2-year sentence or whatever he's facing so he doesn't go to jail. And so I maybe further say, well, already there's electronic monitoring, there's geographical monitoring. You can make an order in which an offender has to wear an ankle bracelet to monitor where they go. That's available here under what's known as an intensive corrections order in my state, in New South Wales. And so just make an order where it's brain monitoring. You're already allowed to do electronic monitoring. So, but now then there's the question of this. What's happening is now the judge is being asked to make an order that the offender have their brain monitored 24/7 with an automated decision-making process that decides when therapy is needed. And there's some human rights dimensions to that, you might say. And so the one thing is mental privacy. Maybe this brain data that the device is probably accumulating, maybe it might be remined for some other purpose, make some other inferences about the offender's health or their likely future behavior in some other context. Who runs it? Is it Meta or Elon Musk company Neuralink? What do they do to look after the data? And then there's also issues of autonomy. So it is a person who has that brain device that just, when it looks like they're going to do something that's antisocial, it acts to stimulate them. Is that person's autonomy being infringed? And so that brings us to a human rights dimension to this. So I'm a member of a group called the Minding Rights Network, which is an international group of scholars who are looking at the human rights dimensions to neurotechnology and some other technologies, actually. And then there's also this New York-based organization called the Neuro Rights Foundation, which is actively campaigning to have some new human rights instruments created, because the argument is that the human rights structure that we have generally around the world was largely created at the end of World War II and the aftermath of World War II, Universal Declaration of Human Rights and the subsequent covenants. And they won't think about this kind of issue where there's the possibility of infringing mental privacy and that sort of thing. So some people are arguing that that needs to be reconsidered, and maybe some new treaty, for example, perhaps. And so I think, if as presumably is the hope of the various investors in neurotech, so Peter Thiel, Meta, through their neural interface part in Reality Labs, Elon Musk through Neuralink, there's a commercial interest in that, and presumably they think there's going to be more wider uptake of neurotechnology. And so I think that means there's going to be more legal issues, human rights issues, and a big part of the aim of this report for the Law Society of England and Wales. And I have to say, I think it's great that the Law Society of England and Wales have people who are engaged in foresight, so that my report went out as part of the Horizon series, where they're looking to this, not just tomorrow, a bit further into the future. That's why I think it is important. And they also think it's important to get a debate going amongst lawyers about how to respond to all of this.
Yeah, absolutely. And I already saw responses to your published report. And some responses were in the form of articles. Could brain chips be used to control crime? So definitely it provokes the debate, which is very important, because indeed the technology is developing and developing very rapidly. So in terms of looking at law in neurotech, what will be your next focus? And another question is, how do you see the field of law 50 years from now, when probably we can expect a very wide distribution of neurotech in the world?
Right now, I've got a couple of papers that I'm committed to, and they both relate to neurotech in the context of the criminal law. But maybe next year, I'd like maybe try and get onto a book project where I maybe, try and draw on some of the work that I've done maybe in the Law Society of England and Wales paper and turn it into a book. I've got a couple of things to do before I get to that. And also doing some talks. I'm going to do some talks about this, and maybe I might do some short pieces from media sources, because I'm keen to get the discussion going. In terms of the next 50 years, wow. I think it's a monitoring thing. Like, one of the questions is, how far can AI do some of the tasks that lawyers currently do? That's one question. And the future direction of law is contingent on that. The other one, the one that I've sort of drawn attention to in this report, is the question of to what extent lawyers might start to employ neurotechnology and perhaps try and use it to sort of keep up with the machines if the machines are starting to gain ground. I think it's just a matter of monitoring the various trends, the sort of AI trend and also related trend of neurotech. And right now, the biggest factor for lawyers is certainly AI and machines doing things like performing discovery, which is a sort of legal task that junior lawyers have been heavily involved in. But the neurotech thing might start to become an emerging issue and is something worth monitoring. And also, in any case, because of the commercial activity, there's going to be legal issues coming up. Lawyers are going to have to guide neurotech companies through the regulatory approval process. They'll have to scratch their head and think about strange new issues where it's not clear what the prosecution has to prove in a criminal matter and things like that. That's about it, really. It's not just a matter of watching. I think there has to be thought put into regulation now. So the Chileans, they've changed their constitution to take account of developments in AI and neurotech. And one of the major proponents of the change was Senator Girardi, and he made the point about social media. And he said, well, social media, we're a bit slow to sort of address the issues surrounding social media. And now it seems to cause some problems for the democracy and that sort of thing, and other problems. And it's quite entrenched. It's hard to know what to do now because it's so entrenched. I think the most important thing is that thought and also action is needed now to sort of try and guide neurotechnology in a way that maximizes the wonderful benefits that I described, particularly in the therapeutic side, and tries to minimize the downside. So I think that's the challenge for lawyers.
Thank you. And what would you recommend to lawyers who actually want to specialize in this field of law for neuroscience and neurotechnology?
I think a good thing would be to read my report. Obviously, I'm biased because I wrote it, but it is kind of the first attempt to try and do a sort of overview of what it means for law and lawyers. And then, my own specialization is probably as a sort of somewhat philosophical criminal law scholar. And I think people need to consider, once they understand some of the technology and some of the general issues, and try and think about what it means for their own area. So if they're an employment lawyer, what does it mean for employment law? Or if they're a contract lawyer, what does it mean there? And also to just consider what might be done to guide the development of this technology in a way that is socially palatable.
Thank you very much. And the last question, how people can learn more about what you do? Maybe you can mention the website where they can find this information, even about the report that you created. And also, if they want to get in touch with you, what would be the best way to do it?
The report is called Neurotechnology, Law and the Legal Profession, and it's published by the Law Society of England and Wales. So if they just Google that, they should be able to get it. In terms of finding me, actually, if you Google my name, you can find me. I've got my university website and personal website, so I'm pretty easy to find. They're the first two names that appear. That would be the best way. And that's got my Twitter and LinkedIn and all that stuff.
Thank you very much, Allan. If there is anything else you want to mention to our listeners before we end our today's podcast?
The main thing is the technology might become quite significant, and it probably does need some thinking and some action to try and channel it in a way that maximizes the benefit and minimizes the downside.
Thank you so much for this thought-provoking podcast. I appreciate you being here with us. Thank you.
Thanks very much for the invitation.